It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
And that's right. We are here live in the studio with FLA Law on the radio. My name is Jacqueline Bryant, and I am one of the personal injury attorneys at Perinick, Caulfield, Averill, and Noyes. And I have my special guest and co-host with me tonight, Lori Robinson.
Great to be here.
Thank you, Lori, for joining me. It's been a little bit of a while since I've been here in the studio, and I think Lori as well. So we're glad to be back. I'm sure you've gotten tired of hearing Matthew Noyes' voice.
I don't know. Matt might be listening.
Just kidding. But of course, we love doing this, and we consider it a great service to our community. So we're happy to be back in the studio tonight for FLA Law, live on the radio. And as you know, this is a live call-in legal talk show, which means you get to call in with your legal questions and have them answered live on the air. So what I'm going to do is, of course, give you all the ways that you can reach Lori and I in the studio tonight so that you can have those questions answered. And we'll, of course, get to chatting about some personal injury topics this evening and kind of let you know what the show is going to be about. But first and foremost, while the lines are open and clear, I'm going to give you the call-in number. It is 727-441-3000. Again, that's 727 area code 441-3000. That's the number to the station for you to call in tonight, ask your legal questions, and have them answered over the air. Now, if you are not one who likes to talk on the radio, maybe you don't want to hear your voice coming through the speakers of the radio, you can tune in through two ways online. We are streaming live on the law firm's Facebook page, and that's Perinick, Caulfield, Averill, and Noyes Injury Lawyers. That's how you can find us on Facebook. If you're not sure, Perinick is spelled P-E-R-E-N-I-C-H. If you put that into your search bar on Facebook, you'll be able to find us, and we are streaming live. You can see us in the studio. And drop your comments in the chat box feature, and you'll be able to actually will read your comments and questions right over the air as well. We are also, hopefully in a second, or should be now, going live on YouTube as well. Is that right, Matt?
Yes, ma'am. We are already live on the firm? Yeah, the firm's YouTube channel. We're already there.
So the firm's YouTube page is live right now, and you can watch on YouTube as well if you're not a Facebook user. Hopefully everybody has access to YouTube, and the name is the same on there. It's Perinick, Caulfield, Averill, and Noyes Injury Lawyers. So now that you've got all the different channels and ways to watch us, we hope you tune in tonight and ask your questions over the air. As you know, we are personal injury lawyers, so that is our main area of expertise, and we're going to touch on a few different topics tonight. But of course, any legal questions you have, feel free to throw those out to us over the air, and we will do our best to tackle those. As you may know about Lori, she is a board-certified trial lawyer. So, of course, if you have questions about trial or litigation, Lori is your person. I know you probably heard from Brian Caulfield, who was on the show last week. He's also a board-certified trial lawyer. So you've had some great opportunities every Tuesday at 5 to really speak to some knowledgeable attorneys who can give you some great insights. So with that being said, let's go ahead and jump into some topics this week. And I felt like it would be a good idea, Lori, to talk about some things that are maybe surprising to people when they get into an injury case or a workman's comp case or even Social Security disability, and they meet with us. Sometimes I feel like the things we tell them might catch them off guard, or they're just not really prepared to hear that. And so I wanted to kind of talk about some of the ones that I think are really either surprising or just kind of little known facts about certain areas of the law. So first, I think we should start with workman's comp.
That's one that is a great surprise in many areas to people because they just have no idea.
We could probably fill up a whole show with just workman's comp. But with that being said, I think one of the biggest surprises that people have is the fact that you can't pick your own doctor, right?
Yes, the workers' comp law, like so many laws, has changed over the years, but it's really over the years gotten more and more restrictive. And one part, though, that's pretty much been there all along is you don't get to go to the doctor that you want to go to. And I can't tell you how many times, even on a personal level, and people will ask me, and that, something happens, they don't want to have to deal with workers' comp. They don't want to have to wait. They want to go to a doctor. Maybe they're actually dealt with, but the system isn't set up like that. But the minute you go to a doctor on your own and explain your circumstance, that it was something involving work, boom. That's supposed to be handled under the workers' comp system. Health insurance is not going to pay that. It should be workers' comp. And so then you get into the workers' comp system. Obviously, very important to report the injury right away.
Absolutely.
And then you're going to have to maneuver through that system, which is really difficult because you just, well, in a way, it's simple. You got to do what they want you to do in terms of going to the doctor.
If you know the law and you understand the rules, you're right. It can actually be a simple system. It's very much kind of laid out administratively. But for the common individual, the everyday worker, I feel like the way it's set up is just not ordinarily what you would expect.
Right. And the real problem that comes along, obviously, with workers' comp selecting your doctor is, initially they're probably going to send you to the clinic. And then, you have some problems. Maybe you need to go see a specialist. And the specialist they send you to doesn't seem to be listening to you or paying any attention to you.
Oh, exactly.
And they rather quickly determine you're fine, and you're not fine.
Right.
So that's where it really becomes an issue. And so but you're still stuck with that workers' comp environment of having to go through the authorized doctor.
Authorized treating physician, right. And so what happens then, I guess, for the average person, and sometimes this happens when clients come to us where they don't know that they have to go to the authorized treating physician, and they've gone to their own physician, and this physician says they need a surgery or they need injections, and they've recommended all these things outside of the work comp system. Is there any way that can be used in their favor to help their case at all?
In a sort of as a side note, maybe, but because ultimately, obviously, if you come to us and that's the situation, then there's some information, but you're going to have to end up requesting an authorized doctor within the workers' comp system.
Right.
And they're going to have the right to their own evaluation, their own opinion on things. Yeah, and
which could be completely different from the one you got.
Readily be completely different. And in the workers' compensation system, none of that evidence from your doctor is even going to be allowed to be introduced into evidence before the judge. It's
that's the shocking part. Even if you have a reputable board certified physician who has seen you outside of the comp system, who says you need X, Y, and Z, if that physician is not authorized treating physician or an independent medical examiner or an expert medical advisor, then those opinions are inadmissible, like you said, and that's a hard pill for a lot of people to swallow.
It's the part of the workers' compensation system that's actually very complicated, and why people should seek out an attorney, certainly the minute they're having any potential issue. And many times it's a good idea to have a lawyer on board to just advise you and be ready to jump in if there is a problem. But, there are ways to get an independent medical evaluation, but it's very, very complicated, depends on the particular situation. The only thing you personally can do in the workers' comp system is one time. You can ask for a change of doctor.
That's what I was going to ask. So they get to choose your authorized treating physician, but there is a way that you can at least change the doctor, right?
Right. But as I mean, we have to be very careful about exercising that one-time change because it is literally one opportunity to change one time. So if you have a situation where you might see a neurologist, an orthopedist, or whatever, one time, one doctor. So you don't really want to give that up.
I've been practicing now for about 12 years, but I feel like that's always been the standard since I've been practicing.
Yes, it has been. Yeah.
Now, wasn't there a time, though, I think, where you used to be able to change per specialty?
There used to be, yes. It used to be per specialty, and there actually used to be a true second opinion option, but that was a long time ago.
Yeah.
So they make it tough. So
I don't know that things have changed for the better, unfortunately.
No, they have not. I mean, they've really responded to workers' compensation as an insurance issue for the employer. And so the insurance companies lobbying the legislature have been successful in really restricting the rights of the injured employee. And that's actually unfortunate, because the whole purpose of workers' comp originally, it was supposed to be this administrative system that you didn't have to get into who was at fault or whether there was negligence. You just send that employee right away to get the medical care they need, get the wages if they're out of work, not able to work. And that was all supposed to be smooth, so smooth you wouldn't even need a lawyer. Well, no. Unfortunately, that is not the way those things worked out. And it's gotten more and more and more restrictive.
It's quite the opposite.
But there still are, there's still a basis to fight for the employee's medical care and for their wages if they're unable to be working during that period of time that they're in the recovery phase. So it's not like there's no opportunity to get care that you need, but it is very restrictive.
Sure. And there's even times where I've had clients who thought they used their one-time change because their doctor did change. But sometimes the doctors change not because the client requested it, but because that doctor retired or the practice closed down, and there needed to be an authorized treating physician on the case. And so they got a new physician and they thought, well, I think they've already changed me once. That doesn't actually count as the one-time change, right?
Right. That's why, unfortunately, people need lawyers, because the intricacies of the system are very, very, it can be quite challenging.
Right.
And as we just said, that one-time change, that's like a precious gem, because that's really the only easy way to ultimately get another opinion. But of course, you're still going to be on that list that the workers' compensation insurance company has of people they're going to authorize, physicians are going to authorize. And all the companies are different. Sometimes they have, pretty good physicians. Sometimes they have not so good physicians. But mostly what you're up against is because the workers' comp system is set up on a schedule for what they have to pay the doctors is just such a fraction of even what health insurance pays. So the doctors are in a position where the pressures of modern medicine mean they're not going to spend the time maybe that they should. Now, that's not to say that, as I say, it just depends on who you get, and there's some very good doctors. But
it's sad. I've heard so many times where clients have said, the doctor told me I should just settle my case and come back and see them outside of work comp. And it's like, boy.
A little too much truth there, but it's tough. But we have to work within that system. If you're injured as an employee, we got to work within that to get you the care you're entitled to, and hopefully get you better.
Right. And the work comp treating physician has a lot of power in these cases when it comes to the recommendations that they make or the restrictions and limitations that they give. And so another thing that I wanted to touch on that people seem to be surprised about is that when I'm hurt after an injury, I know my capabilities and my limitations and what my job requires, and I physically can't do that anymore. And so they take time off and they decide to stay home and they don't work. But the work comp treating physician never said that or never gave those restrictions. So could you explain how that
because I think that,
system?
in our law practice, I think that's probably an area of counsel we get involved in very often. So you've gone to the orthopedic doctor and you've gone through a little physical therapy, and the doctor thinks, okay, you should be able to do your job, and they release you maybe to light duty, but your job, it's something you could, in theory, be able to do, because they're not really thinking about the pain aspect.
Exactly.
And so what ends up happening, the client is saying to us, the injured employee is saying, but I can't do it, just like you're saying. And so the counsel we have to give is you've really got to try. You got to go in and try. And if you're unable to do it, let that be clearly documented so they send you home on that basis. And then you go back to your doctor, and the doctor has the opportunity to reconsider the restrictions.
Exactly.
And that's the path. Because if you don't do that, and of course, the person has the right to say, I'm sorry, I just can't do it. But if you don't do that, you give up your right to the wages.
Right.
Because, from the perspective of what's showing in the record, the doctor said you could do it. You're really refusing to do it. And so then the employer doesn't have to provide under the insurance the workers' comp wages.
Exactly. Because that gives the carrier the opportunity to say that you're now limiting your own income.
Right.
Because the doctor did not say that you can't do it. And you and the doctor now kind of become at odds with one another as far as what you think you can do and what the doctor says you can do.
And you don't really want that.
And you don't.
You really got to, you've got to kill them with kindness and really create an opportunity for the doctor to maybe have a little more understanding about that. Because that's without that medical documentation, unfortunately, you're going to be giving up valuable rights. Yeah, obviously you don't want to injure yourself. And you have to make choices. But I would say over the years that most times when people understand what the situation is, if they will follow that recommendation of just go try and clearly document what's happening, if you really can't do it, then usually it will work itself out so that the doctor will be able to rectify the situation. Not always, but usually.
Right. So that kind of brings us forward then. So now we know the work comp provides the physician. There's some remedy there if we want to change, but it's only one time. And we have to kind of communicate with the doctor. We want the doctor on our side if there's going to be limitations or restrictions. But let's move forward, I guess, progressing towards what might be the end of the case where the doctors have now released you from care, or there's some treatment that's being recommended that you want to do outside of the system. And now you've gotten to a point where you're ready to resolve your case. I think people are sometimes shocked to know that if you settle your case, you have to resign from your position.
Almost always.
Yeah.
99% of the time. Very unusual, but you wouldn't. And that's a requirement imposed by the insurance companies typically.
Exactly.
It's usually not your employer that's thinking in those terms, but the insurance companies are.
Right.
That's a big one. But, depending on the situation, I think that to me the most challenging cases over the years are the people that have worked in physically demanding jobs, and maybe they get a little bit older. So maybe you've worked at a Home Depot or a Lowe's or UPS or, one of the delivery companies, and you hurt your back.
Right.
And you really can't. It's not a good idea even to push yourself to continue in that type of work, but it was a good job for you. That's very, very tough. But in those situations, many people will decide for a variety of reasons, because of how difficult workers' comp is, that it would be so much better to just take control of your own healthcare and destiny, get a lump sum settlement, deal with your health issues on your own, and then move forward. But it really does depend on what your medical condition is, whether you've got other options for health insurance.
Exactly. Because once you resign, if you have insurance through your employer, your insurance will end at that time as well. And so if you were planning on continuing your care outside of the work comp system, you can't do it through your insurance unless you're going to, pay something into like a COBRA situation.
And
where,
usually that's so expensive.
And it's so expensive. And so those are really all the things that we kind of have to counsel people on to make sure that settlement is the best option, because sometimes it's not,
Yeah. I mean, it's, we have people that we monitor their workers' comp claims for years, and so
I think Matt told me about one file that I think you all have that's older than his daughter or something like that. I was like,
so
my goodness.
But many times, he likes to use the way of speaking of it is sometimes you just want to get a divorce from the system. And I think, if you're, and a lot of times, particularly if you're in a situation where you're not really going to be able to continue that work, it does make sense to look at it. And then, with settlement monies, you purchase some insurance. If you, ideally you won't need a whole lot of extra care, but if you've had a significant injury, chances are you're going to need to make some provision for that.
Absolutely.
And that's the difficult challenge for people.
Well, that's a great segue then to my next question. But before I ask it, of course, I just want to remind everyone the lines are open. The number is 727-441-3000. Right now we're talking about workman's comp. But of course, if you have any legal questions that you would like answered, feel free to give us a call and ask those questions over the air. But Lori, that's a great point when it comes to the settlement issues. That brings me to, what are we talking about when we look at the damages, and what can be claimed when we're talking about a lump sum.
That's, of course,
settlement.
the very biggest surprise that people have to learn about in workers' comp. Everyone understandably values their claim in terms of what they've had to go through, what they're still going to have to go through, if you had an auto accident or any other type of personal injury claim, we would be talking about your pain and suffering, which is really, in many ways, the biggest part of an injury. But in workers' comp, that's not recoverable at all. The law only allows for consideration of the hard economic losses, which are going to be the actual medical expenses and the care you need, the cost for that, based on what workers' comp would pay for it, which is, as I mentioned earlier, is like a fraction of what health insurance pays.
Exactly.
A fee schedule that's very, very limited. And then, any lost wages calculated under the workers' comp system that you might need if you were going to be out for a surgery or something like that, out from work. But that's of course based on the state established workers' compensation rate. So there's a maximum level. You get 66 2/3% of your average weekly wage that they calculate over a period of 13 weeks. There's a lot of math in all of this stuff, actually.
There's a lot of math, especially when calculating the indemnity, for sure, the wage loss. And so I think people, like you said, are very shocked when they learn that the fact that I can't play with my kids anymore like I used to, and my back pain now prevents me from being able to enjoy certain hobbies and activities, and it has limited me in that way, does not even factor in when we're talking settlement in the work comp system. And that's usually very difficult for people to kind of digest. I think is
probably the hardest part of all, that can't be taken into account. But unfortunately, that's the way the law is for workers' compensation. It's an administrative system that is supposed to be easy and everything for people, get what you need quickly. Not necessarily all that quick. And unfortunately, doesn't really cover a good portion of what you're dealing with. But having said that, I mean, if you have a significant injury, and especially we'll see this with people that are, even they're a little bit older doing those difficult jobs, you can still get a substantial settlement, but it's rooted in the things we're talking about, not your pain and suffering, but in the need for care in the future, perhaps a possible surgery and that sort of thing.
Those things are the ones that kind of drive, the value of your settlement. Now, bonus question here, since you are the board certified trial lawyer.
The lawyer.
So if I am not happy with the offer that I get in a work comp settlement, can I just take it to trial? And get a jury to award me something?
Oh, my goodness. We had a young man at a recent mediation, which I will not speak about because mediation is confidential. And he's a very nice young man.
Hypothetical.
But he, very hypothetical. But it's actually, I don't know if I've ever spoken with a client that didn't exactly put that, because you feel like you've been wronged by the system. They drag everything out. Let's just go to trial. Nope. The workers' comp system, you'll never have a jury trial over the value of your case. The only thing that's ever litigated in the workers' comp system are just if there's an issue. If they don't send you to a doctor, or you need to get another doctor, or they aren't paying your wages, those are things that you file a petition for benefits. You go before the judge, the workers' compensation judge, and the judge can decide those kind of issues. But not the overall value of the case. So that has to be something that's negotiated between the injured employee and their attorney and the insurance company for the employer.
Exactly. So there's no judge who can award you X amount of dollars, or a jury that can say this case is worth this and the carrier should pay this. Fortunately, it does not happen in the workman's comp system. And so, again, these are things that surprise people, I think. And so maybe little known facts or surprising facts that we're touching on tonight. I think that we can probably segue into our next, topic. But before we do that, I want to let you know that we're still streaming live on Facebook. Parenting Caulfield, Averill Noise Injury Lawyers, and we are also streaming on YouTube. Before we jump into some little known facts in the Social Security realm, I think it's time to probably take a quick break so that we can make sure the lines are clear and open so that anybody who has questions about workman's comp, Social Security, they can get through the lines, and we'll come right back and start talking about some of the things that I think surprise people when it comes to Social Security disability. We will be back shortly.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the TAN Talk Radio Network.
We are back from our break. Thank you all for tuning in. Once again, as you know, this is FLA Law live on the radio, and we are the injury lawyers from Pernick, Caulfield, Averill, and Noyes. While you're listening to the show, if you want to check us out online and find out who we are, you can find us on voiceoftheinjured.com. I am here with my co-host, Lori Robinson. We were just touching on a few topics here in regards to things that we think are surprising for individuals to learn about some of the areas of law that we handle. And so we were talking at the beginning of the show about workman's comp, but of course we're going to kind of now segue into Social Security disability, because like you said, there's sometimes when people just can no longer do the work that they used to do, especially as you were mentioning, individuals that have accustomed to doing jobs that are very heavy or labor intensive type work, and they're now older in age, and those skills don't always transfer into other things. And so they end up having to file disability, or there's all kinds of scenarios and situations where individuals find themselves in that point in life. But of course, we handle those types of cases as well. And another surprising thing that I think people will I'd be a little bit confused about is whether you can or can't work while trying to be approved for Social Security disability, right?
Right. That does come up quite a bit. And I think it's very important to talk about workers' comp and the Social Security together, because, and this is why it really is a good idea if you have a significant injury at work, really in any setting, but get a little legal input, because there's just so many factors to it. But a person that is applying for Social Security disability, the legal standard for that is that you are unable to perform what they call substantial gainful activity. And that means work that's pretty much full-time, but that would currently this year earn more than $1,470 gross.
Right.
Not very much, really.
It's not a lot. Yeah.
Now, having said that, I've had many clients over the years that did work very, very part-time and ultimately were approved for Social Security, but they literally couldn't do more.
Exactly.
And so, if a person does a little bit but is limited by their physical impairments, that's not inconsistent with filing for Social Security disability, but it does introduce the question of whether the person is limiting their income or
how much more can they do. And the worst thing that I see fairly often, and honestly, if you can work, great, but that's much better than having to go that route. But you don't want to more or less shoot yourself in the foot by knocking yourself out, really doing more than
is really a good idea physically, and then earn just a little bit over that $1,470,
Right.
which
it's such a low threshold.
Yeah,
It's easy
right.
to go over that. I would
yes,
think.
I mean it's like so when you do that though, now you can't qualify if you are $1
Exactly.
over that. So
Exactly.
so it's the kind of thing we always counsel people to talk with us if they're going to work. It's not that you can't,
Right.
but you and if you're able to do more, great. That's obviously the best case scenario. But it is something that has to be kept in mind in terms of what you're really capable of doing, because Social Security is looking at 12 consecutive months that the person is unable to work because of their physical or mental impairments at the level.
I'm glad you mentioned that, because I do get questions sometimes about, is there a way to get on it for a short term, like a short-term disability?
Right. A lot of people would like that option.
Exactly. And unfortunately, like you said, it has to be at least 12 months.
Right. Now, that isn't to say that if you are approved for Social Security, or even I've had hearings where the person, by the time we got to the hearing, they'd had a very serious thing happen, but I'm going to just say it, praise God, they got better.
That's what we hope for.
That's exactly what we hope for. That's really wonderful. Well, you can qualify for a closed period of benefits if you, so long as you had that at least 12 months.
Right.
And the other thing is, if you attempt work while your claim is pending, and it doesn't work out because of your injuries and your condition, then that can be, if it's less than 6 months, it can be considered an unsuccessful work attempt. But
and I think sometimes judges tend to look favorably on that. If I'm not speaking out of turn, I just think that they like to see when you try, or you made an effort, or that you're not, or if, even with the closed period situation where you're not trying to present a disability that it no longer exists, but you're only presenting what the evidence shows.
Right.
Yeah. And I think that they tend to maybe see that as being more credible. And
so, I mean, it's because the truth speaks loudly, actually.
It does.
But again, it is something to get counsel on, because there's so
Absolutely.
many little nooks and crannies to the whole thing. And
Absolutely. So just because you're working does not necessarily automatically disqualify you. It can become an issue depending on how much you're earning, right?
Right.
Yeah. And that's what I think people need to really talk to an attorney about, is the level at which you're performing in terms of your work. But even more so is an issue are the work credits that are being earned.
Right. So very good idea, which I would say I've talked to many people, I'm sure you do as well, that are still working, but they're really wondering if they can keep it up, and they want advice. And I encourage that. So the person gets an idea, because unless you've been through it, you have no idea.
Exactly.
It's not what anybody really expects. Well, the thing with Social Security disability is, in effect, you're getting your Social Security retirement early for a medical reason. In order to qualify for that, though, you earn work credits each year that you work. You get a maximum of 4, and it doesn't really take that much. I mean, it's maybe $6,500 a year type thing. It's not that much to get your full 4 work credits. But to qualify for disability, your work credits have to be relatively recent. And it usually works out to be approximately 5 years after the person stopped working, something in that ballpark. So we do have situations where people have a lot of work credits, but they stopped working quite a long time ago. And then they finally think, wow, somebody tells them, you might qualify for Social Security disability. And what's happened is, you've got to go it's very difficult to go way back in time. In fact, you can only get benefits a year before your application. But also, you have to be able to prove that you met the criteria, the medical criteria, within
during that time period.
Yeah, and it's
very difficult,
virtually impossible to
finding
go back.
all the records and getting those in front of the judge so that they can evaluate what your condition was at that time is very challenging.
So it really kind of means that the best thing to do if you have a serious medical or mental impairment or combination that's really impacting your ability to work is to get a consultation with an attorney.
Absolutely.
We're happy to talk with people so you understand what your rights are, what's required, what's involved. The other thing people do not really grasp is it's a medically driven record. So you've got to get medical care. Active treatment. Yeah, you've got to do that. It doesn't, what you say, actually, it doesn't matter for the Social Security record. It has to be reported to doctors and largely specialists.
I can make all the arguments I want, but if it's not
so
in the
sad. I had one
records,
recently, and I know that she had a lot of problems, but her record was such that it had been she didn't have insurance, and you can get help through the Pinellas County Health Department, but it takes a lot of determination.
It does.
I mean, it does, but you've got to get the medical documentation of what's going on, because if you don't, and you don't have it within that period that we're talking about before those work credits expire, then you're not going to be successful with Social Security Disability. Now, you could qualify for the welfare version of the program, which is SSI, but that means you have basically hardly any assets.
And that's exactly the next point that I was going to make. People assume that, okay, well, if I haven't worked in a while, does that completely exclude me? And the answer to that is maybe not. You could potentially apply under that other program, but now you have to look at all the income criteria and your resources and your assets. And so sometimes you have a situation where sadly a person has stopped working for so long that they no longer have the credits, but they have a pension, or they have a 401k, or they have some sort of inheritance from a family member that they've been living off of all this time. And they unfortunately have too many resources to qualify for the other programs. So. Right.
Yeah. And that's, the welfare version of it is really a truly destitute situation. No more than $2,000 for an individual, $3,000 for a married couple, one car, then they have all these other rules and things. So when you're at that point, then at least that's an option for you. But if you've had the Social Security work credits previously, it's just always something to be looking at, when a little more current in time. And I think people, they don't think about it. I mean, I've had a lot of people over the years that just really, they just don't think about it. And therefore too much time goes by.
Exactly.
And now you can't really establish what your medical condition was in terms of that particular time frame. So hopefully we'll be planting a few seeds so that people have it in the back of their mind. If you have a family member or friend that is in a situation that might be something that they should consider Social Security disability, then
if you believe they're medically disabled and they haven't been working for some time, and you see the years are now adding up since they've worked, you should certainly call us right away so that we can determine, number one, if the condition is medically severe enough, and number two, have they been out of work so long that they no longer have the work credit? So those are things that the sooner you get into and speak to an attorney about, the better. Like you said, if that time goes by, it's harder to go backwards. So even if you're still actively working and you're thinking, well, I haven't been out 12 months, so I don't think I would qualify, I would still recommend giving us a call, because that way you have the guidance and understanding of how to proceed.
Anyone that's in a position where they're thinking, I'm not sure I'm going to be able to do this.
Exactly.
That when you're going through that thought process, then do your due diligence. You can learn a lot online, but honestly, I know you'll say this, Jacqueline. I mean, I've been a lawyer for many, many years. Social Security has so many nuances to it, so many rules. I mean, it's crazy. Yes. I mean, there's probably not a day that goes by that I don't learn some new thing, on it. And so
I remember my first hearing, I was covering it for a now retired partner, Jay Averill, and I literally had just started working, had never picked up a file. So I'm learning Social Security disability law within like a day. And I remember sitting there and I'm hearing all these phrases and I'm like, what language are they speaking? And the vocational expert is throwing out codes and SVP. And I'm like, what in the world? So it is very complicated. And it can be a system that trying to learn on your own, Googling things, which, like you said, there's a lot out there and you can get some very good information, but you just need to have the appropriate counsel.
I would say, it's so good to Google and get sort of the lay of the land, but for your particular situation, call an attorney. We're happy to speak with you and give you some input on how you might plan for the future. And that's really what I think of it as is, be realistic about what your future looks like. The other thing, because you have to know, it's almost never quick.
Right.
I mean, it's a
very
long bureaucratic process.
Mm-hmm.
So it's not like you can go apply and, if you're a Social Security retirement and it's all, you can apply in a month and maybe still takes a few months for them to get the system rolling. But for the typical disability claim, there's nothing that's straightforward. So it's months and months and months. And for most people, years. For most people, it's probably 18 months, 2 years to go through the whole process.
And that's the other thing that shocks people. They're like, but it's clear as day. Look at my records. Look at my reports. It's all there. I'm clearly disabled. Why haven't they approved me? But it's all bureaucratic red tape. Oh, yeah. And such a long process.
My very first Social Security case was when I was in West Palm Beach, and I'll never forget. It was a fellow that I knew from our church, and the poor man was doing some tree trimming somewhere, and he sadly he had an accident and he cut off one arm.
Oh my gosh.
He was injured badly. He couldn't use it.
Oh my goodness.
They denied him because, of course, we have two arms. Well, this man worked in a kitchen in Belgrade, Florida. There was not going to be something else he could do, and he was an older gentleman that was, and so of course I knew him from church, and so I was very happy to take that on, to get involved.
Sure.
But it was quite an eye opener because you're reading, we know you feel like you aren't able to work, but
it's
like, really?
You have another arm you can use.
No, so
it seems cold and
the way they're so systemized. They have all these little charts and things, and how old you are makes a difference.
Grids and different things. Right. Yeah, for sure. So I think the takeaway there is, of course, get evaluated, get an evaluation from an attorney early on, even if you're unsure about where you stand with your work credits or your medical or the fact that you're still working. It's better to, at least have a consultation at the beginning so that you don't, unfortunately, I guess what's the word I'm looking for? You leave benefits on the table because you stayed out too long.
Yes, right.
So that's the takeaway, I think, for that. And that, I think, is the best
advice. And also
advice.
Potentially put yourself in a position where something that could have been of help to you isn't even available.
Exactly.
And that is really tough because
Especially
you paid into the system. If you worked and paid into Social Security, those benefits are things you've earned.
You've earned it. Yep. You can pull out your pay stub and see where you've been paying into that system.
It ought to be there for something.
Yeah, exactly. So that's of course our little Social Security segment. We're touched on a few things tonight. If you've been listening in, we said that we want to talk about the things that we feel surprising to some folks when they call us and they ask questions about certain areas of law. So that's what we're talking about, Lori and I, tonight. So we touched on workman's comp, some of the things that we think are surprising to people and little known facts there. We've talked about Social Security. So next, Lori, I want to talk about something that is equally complicated and confusing to some people, but it's sovereign immunity.
Oh my goodness.
So there's these cases out there where you sue the government. Maybe it's a slip and fall or trip and fall, or maybe you're even involved in a car accident involving a government, vehicle or a government employee. People are surprised to know that there's different rules and caps and things that come along with that, right?
And I guess, being a lawyer, so of course, our law comes from the common law, actually originally from the common law of England.
Yeah.
We fought a law fought a revolution to free ourselves, but we still took the law.
We kept a lot of things, right?
We kept a lot of things, but we don't have the barristers with the wigs and all that stuff. But,
oh, thank God. In Florida.
That's true.
I couldn't imagine.
But yes, so sovereign immunity represents an area of the law that the government is protected from being sued, basically. Right. And so actually we have in our Florida Constitution a little provision that says the legislature can decide and they can pass a law and say on what basis you can sue the government.
Exactly.
Now, how many times have we had conversations with people? I've engaged in them myself where you say, that's outrageous, or some code enforcement issue or something you see that the government is really fallen slack on. But there's actually only a narrow type of case that you can actually sue for. And so one of the laws of sovereign immunity, and the sovereign being the king, the government, is that you have to follow these procedures, and there's limitations in how responsible they can be. So
exactly.
So we'll see we are permitted to sue by for torts, which are personal injury claims,
Right.
and that's obviously what we get involved in. But there's a lot of nooks and crannies again to what's involved there. You have to give a formal notice to the government agency and the Department of Insurance, often financial services. It used to be now that it's gotten a little more complicated now, because I know you had a note to me earlier today. I was thinking that used to be you had 3 years to provide that notice.
I'm still not even sure how this is going to work now.
But I guess since the statute of limitations has been reduced to 2 years, it used to be 4 for normal personal injury type actions. I think you got to be moving on that pretty quick, because so as a practical matter, now normally you come to a lawyer that handles personal injury. We're going to put those notices out right away.
Exactly.
And because you cannot actually bring your lawsuit until they've either denied it or 6 months have passed.
Exactly.
Giving them that opportunity to investigate.
So under the old law, there could have been a scenario where your statute of limitations might have still been good, but you could have gone past the notice of intent rule, where you no longer can bring the claim because you didn't put it on notice in the 3 years.
So to use your language here, the takeaway on this is we always want to act quick.
Exactly.
That way we don't have to worry.
Yeah, I feel like that's the running theme tonight.
I think so, which is true. I mean, it's just particularly legal rights. It's not the best idea to sit on them.
Exactly. Absolutely. And so one thing that I think is a positive for those that are injured and involved in, claims against the government or sovereign immunity claims is that there are limitations on the fees as far as the attorney's fees and what can be charged by statute. But unfortunately, not so fortunate for those that are injured is there's also limitations on how much you can recover. Right.
So with a claim against the sovereign, against the government, the law limits you to $200,000 per person, $300,000 per claim, which, depending on what's occurred, isn't very much.
Right.
Unfortunately, the only real way to go beyond that is, in some instances, the government entities may have a liability insurance, and they may, if you go to court and you get a judgment in excess of those amounts, they may be willing to settle up on some basis. But the normal thing, and really the only real way to actually recover more than that small amount, the $200,000 individual, $300,000 for the total claim, no matter how many people involved, is to file a claims bill with the Florida legislature.
Yes.
And that's going to be,
that sounds extremely daunting.
Right. And not many are granted. It's the ones that are most likely going to be something you read about in the news. And it's it's a theoretical possibility, but for the usual situation, you're limited to what those statutory maximums are.
Exactly. I just read about one recently in South Florida. It wasn't a verdict. They actually reached a settlement, and there's a well-known firm down there that was able to get a claims bill for $1.2 million for an individual who was a motorcyclist who was unfortunately killed by a school bus driver. The bus driver unfortunately blew a stop sign and killed the motorcyclist, and they were able to lobby and to get the bill passed for the 1.2. Now, that's something that I have not had the pleasure of doing in my career. And so I've always been curious, does it go through the system just like a regular bill, like Schoolhouse Rocks? I'm just a bill.
My understanding really is, when a claim is appropriate for that, then that is something you partner with the few attorneys that have gone through that process and the lobbyists, because this is
much like any bill that needs to be passed.
Right. It's right. This is politics in action, but for a meritorious cause.
It has to be.
But it's very
just any case can make that standard. Yeah. So it's very difficult. And so that's I've been saying it over and over again, hard pill for people to swallow, especially when it's significant injuries, life-changing, but it involves the government entity.
Right.
And so there's that cap, like you mentioned, 200 per person, 300 per claim. So that's something that, you could walk away with the brain injuries and just very severe damages that are limited, sadly.
Yeah. And it's not, as I said, there are specialists that would be knowledgeable about the lobbyists and that kind of thing.
Yeah.
So in the unusual case that would come to that level, but you can see it's going to be very few cases. It's
Very
going to be
few,
something dramatic like a highway accident such as that one. And it's, but in the normal situation, unfortunately, it is a limited recovery.
Right. And so that is kind of the topic for tonight, is the surprising or little known facts in the personal injury realm. And I think, Lori, you did an excellent job touching on all of these various topics. But one thing I wanted to make sure we talk about before we conclude today, and it almost kind of ties into what we just mentioned about the motorcyclist who fortunately was able to, his family was able to recover on the claims bill. But we've seen some very sad fatalities in our own local area here. I don't know if our listeners have heard, but there was maybe 2 and just this past month in July of pedestrian fatality. I think it was on Missouri Avenue, where a gentleman was killed by a young driver who was DUI. And that was a hit and run situation, but they were able to locate him and he was arrested. And then just a couple days ago, a young woman unfortunately killed a bicyclist in Pinellas Park on 66th Street. And I feel like I want to mention that because with these hit and runs and when there's devastating loss of life, the family is usually looking for answers.
Sure.
And they want to hold people accountable, even beyond the criminal system, but civilly as well. And when the person is DUI or there's hit and run, sometimes they don't always find these individuals. And so what is the best way to really protect yourself when you're dealing with a situation like that, where there's a hit and run, you don't know the individual and you can't make a claim against that individual, or they don't have any insurance and they're incarcerated? What kind of parting wisdom would you give for that?
Well, the only potential protection we have in these situations is a policy of uninsured motorists.
Exactly.
And that is insurance that can cover in circumstances involving an automobile accident and injury where there is not other insurance coverage or there's inadequate insurance coverage for the damages. And that's why it is something so important for people to talk to their insurance agent, or, people do things online policy, and it probably makes it very easy to not understand what you're giving up. But
exactly,
really important, because God forbid somebody's is injured or killed, and there's an accident like that clearly was involving a motor vehicle. If you have uninsured motorists, then any resident relative in your home is going to be insured under that policy, most likely. And in that scenario, there may be an ability to recover some compensation for a horrible tragedy. So it's a piece of insurance that is something that should be a part of your standard automobile insurance coverage.
Exactly. And if you are unsure and you would like us to review your policy, just to make sure that you have the proper coverages to protect you and your family in that situation, feel free to reach out to us. Even when the show ends tonight, you can reach out to us at our firm at 727-796-8282. We would love to be your voice. So you can find us at voiceoftheinjured.com. That's a way for you to find us online. Of course, you can put in inquiries online as well about any case that you may have. If you'd rather type it into our website, you can do it that way. And we'd be happy to review your coverages with you and let you know whether you've got what you need to protect you and your family. Lori, it's been a pleasure.
It always is. I always enjoy talking to you, Jacqueline.
I think it was a great show. You gave some great advice. And we will be here next Tuesday at 5 p.m. with FLA Law on the radio. Have a great night.